attendance? All right, starting about 30 seconds. Please sign in. Okay. All right, I have 1:30, so let's get started. Welcome back, everyone. I see about 82 of you, so about 10 people still trickling in. Please be here on time for those who are not here yet. Question before we get started. Anything on your mind? Yeah, Nancy, go ahead.
Professor, this is just about the new, the link. If I try to go join the way I normally would, it requests a passcode, just so you know. I can only join if I go to the syllabus and click on that link.
That's the link I want you to click on.
Okay.
Yeah, click on that link. Just click on the link in the syllabus and she'll let you right in. Yeah, the school created these special meeting rooms for each class, and it's easier to just use that than the code. Okay? All right. And I think everyone else is here, so people should be trickling in. All right. Thank you, Nancy. Let me get started by sort of recapping where we were in the last class and bring it forward to where we are today. We've been discussing this concept of incitement. With incitement, people are being punished not for actually engaging in illegal activity, but for encouraging others to engage in illegal activity. So how do you punish speech? At different points in American history, different lines were drawn. We started with the Schenck test in the 1919 period. And we have the so-called the bad tendency test, or what's also called the clear and present danger test. That if your speech has a tendency to incite violence, it can be punished. Your speech doesn't have to necessarily lead to violence. You don't have to intend violence. Violence doesn't even need to be foreseeable, to use a tort concept. It's enough that it's possible. Right? This is something of an objective standard. Your intent really doesn't matter. Then we get to the 1960s, and the court starts to peel back on the Schenck test. And we have the Brandenburg case involving the Klan rally. And the court seems to say that the government should not be in the business of punishing speech that could lead to violence at some point in the future. Rather, the violence must be imminent, right? Imminent. And that's a term that's not defined by Brandenburg, but subsequent cases define imminence to basically mean right now. A number of you put in the poll, as a 40-minute cool-off period, imminent. My read of the precedents is that's not imminent, right? That there's a pretty big gap between giving a speech and people doing bad stuff about 45 minutes later. You may not like it, but the way case law is read for imminence, it means now, right? It means the person giving the speech is in the place where the violence occurs, and as the word's saying, let's do stuff, the stuff is done at that moment, right? It's not exactly the same as a cooling off period for maybe murder versus a crime of passion, remember from Krim, but it's pretty now. But it's not just a requirement of imminence in the Brandenburg Standard. Your advocacy must be directed, right? It must be directed to violence. So your words need to be fairly clear, right? It's not enough to say words that could be understood to encourage violence, you have to direct your words. Now there's a bit of an intent element there, and it's often very hard to ascertain, you know, what a person directed. Do you look only at the words spoken at that moment? Do you look at the words spoken perhaps before the rally? Do you look at how the people would have understood it in the community? People ask about that, the people who were at the rally, how they've understood it. These are all very difficult fact-bound questions, and my tentative read is under Brandenburg. If there's any doubt, the presumption is in favor of free speech. In other words, if it's a close call, whether or not it's incitement, you give the benefit of the doubt to the speaker and not to the government. That's sort of the opposite of what happened with the Schenck test, where the presumption was the government could punish you unless there was a very good defense, which is what Holmes would have said in the Abrams case. So you're already seeing the court become much more protective of free speech over the past 100 years, and it didn't happen overnight; it happened decades apart. But the Schenck to Brandenburg standard reflects that. The other case we did, Chaplinsky for New Hampshire, is the fighting words doctrine. That was decided in the middle of the 1940s, so somewhere between the 20s and the 60s, but halfway through. And the court seems to say that there are certain words that they're profane that bring you to fisticuffs, so to speak. Like you want to punch someone out, can be punished. It's very tough to reconcile Brandenburg and Chaplinsky. Chaplinsky says you can punish speech that might bring someone to violence. Doesn't have to be imminent. Doesn't have to be intentional. Brandenburg says, no, you can't. You need to have intentionality. It has to be directed to that violence, and that's be imminent. So in some ways, fighting words doesn't survive Brandenburg. We'll get to the Texas versus Johnson case today, where Brennan discusses those two cases, and he's like, yeah, they can't really line up well. So Chaplinsky is a sort of stepchild. It sort of exists, but doesn't really have any weight today. It may make a comeback. Maybe in a different universe with a different Supreme Court, fighting words would become the new basis for punishing hate speech. It could have gone that way, but unlikely now. But in an alternate universe, that could have happened. Maybe still will in a couple of years. When you have a precedent that's not overruled, sort of just lies around forever, right? It's just it's always there. It can be animated at any point. Okay. Question on last week's topics, or the last topic from the last class? No? All right. Let's move on to today's topic. So far, the cases we've dealt with have involved words. There's one exception I'll get to in a second. But every case we've dealt with involved words, criticizing the government, supporting socialism, opposing the draft, calling police fascists and racketeers, preaching hatred at a Klan rally, right? These were all efforts at speech, words. But we had one case, Stromberg, which involved a flag. A flag is not a word, right? I can wave a flag without saying a word. My mouth is shut. Yet the court seemed to assume that waving a red flag was speech. This was a symbol of the Soviet Union. So in the First Amendment, where it says Congress should make no law abridging freedom of speech, the word speech has been interpreted quite broadly. It's not just the written word or the spoken word, but it also includes certain types of conduct. You might call it expressive conduct, that stuff you do conveys an idea. Unsurprisingly, in American history, people have engaged in conduct designed to get a reaction. Burning a draft card, burning an American flag, burning a cross. Remember in Brandenburg, there actually was a cross burning, so that actually wasn't the case we studied last class. And the readings for today pose the question, how can the government regulate conduct that's designed to express a message? Is it regulated in the same fashion as speech, words? Or do we treat conduct, expressive conduct, differently than we treat verbal speech? And the three cases today, I think, illustrate the dynamic very clearly. The shorter answer is the court treats conduct in many regards like speech, although these cases might be a little tricky for you guys to reconcile. All right, any questions so far? All righty. Who's next? Who's up? Denver, good to see you, sir. All right. You want to give me the facts, please, in our first case, O'Brien?
Yes. So David Paul O'Brien, I believe 3 of his friends burned their draft cards.
Why were they burning their draft cards, Denver?
I believe it was possibly in defiance to the draft. It was in 1968, so that was the height of the Vietnam War, if I'm not mistaken.
And just, I want to make this point just very clear. Why would burning your draft card be an act of defiance to the military draft?
I think it's just kind of a direct symbol to the draft, is why they say that. I guess they were making points that it does help administratively. But
No, we're not there yet. I'm asking from O'Brien's perspective, why did he light it on fire? What was his intent there?
I think it's a direct symbol of the draft, your actual draft card, kind of a symbolic showing.
Sorry, so he can't actually stop the draft. That's beyond his power, but it is within his power to burn a draft card.
Right.
Do you think this created a large commotion?
Well, I believe they started getting physical with him.
Who's they?
It looked like there was a large mob or sizable crowd that had witnessed the event.
Did he burn this draft card on like a hippie commune somewhere or a Grateful Dead concert? Where did? Sorry, it's me. Where
steps of the South Boston courthouse.
He did it in broad daylight in front of everyone.
Right.
He was looking for trouble, wasn't he?
It would seem like it.
Right. Okay. Thanks, Denver. All right. So you have O'Brien here, and he did what many people did in this time period, right? He went to a public place and he burned his draft card. And he did it to send a message. I am opposed to the draft. This is an unjust war. And I'm willing to break the law to do so. He knew there was a law. There was no doubt, right? This wasn't a case where, is this a clear and present danger? There was a statute that prohibited this specific type of conduct. He did it anyway. Now, that was Denver. Who's next? Caitlin, you here?
Yeah.
Okay, Caitlin, let me ask you a question. Why do you think Congress enacted this ban on mutilating or destroying your draft card? Why do you think this law was enacted?
Well, so this case was in 1968, and I think this law was made in 1948. So possibly because we had just had large world wars, and they didn't want any kind of resistance to war.
Okay, so let's take the good reason, right? What's the positive reason why this law was on the books? Just government often has different kinds of motivations. What's like the good reason why they had this law on the books? What was the purpose of these cards?
Just to make sure that you were registered for the draft and to make sure that they had all your information correct.
Yeah, it served a practical purpose, right? People who were running around, the government could find them and get their information. Now, why do you think the prosecutors actually charged O'Brien with this? You think they were really worried about effective record keeping that this Mr. Brown would actually would ever report for duty. Why do you think they charged him?
I can't imagine it was because they cared that much about the card. I think it was more to send a message and to kind of stop any kind of movement if there was going to happen before it happened.
They were trying to stop criticism of the draft, weren't they? Yeah, thanks, Caitlin. We're back with Debs, right? If you remember the facts in Debs and Schenck was opposition to the draft back in World War I, that the socialists in the World War I period were objecting to the draft as immoral. And so why are you laying your life down the line for these capitalists, right? Stuff's not that different. Just in the 1960s, you have the hippies who were opposing the war, and they were making very similar arguments. And once again, the government was trying to punish them. Now, if O'Brien had just gone on a soapbox and started screaming that the draft was immoral, they probably wouldn't have arrested him at this point. I don't think they could have, given the First Amendment. But instead, O'Brien did something else. He didn't hold up a sign. He didn't sing a song. He didn't, pantomime. I don't know, whatever you do. He burned his card because he wants to send a message that I'm not going to follow this law. I'm going to destroy my draft card. Okay. So he was charged with violating the statute, and he violated it, right? There's no doubt. He would agree that he violated the terms of the statute. So the only question presented was this prosecution constitutional, right? Could he be charged with violating the statute? All right. All right. Alexandra, are you here?
Yes, I'm here.
Thank you. You want to walk me through the court's opinion, please, the analysis?
Yes, well, the court ruled against O'Brien, and they kind of formulated this four-factor test known as the O'Brien test, in which if the speech restriction satisfied the four elements, then the court would rule they would look at it with more deferential intermediate scrutiny, but if it would be reviewed with strict scrutiny if it didn't satisfy the four-element test. And in this case, they said that the first two factors of the test were easily satisfied. And so they were actually all satisfied, and they therefore looked at the law with intermediate scrutiny.
Okay, excellent. Thank you, Alexandra. All right. The Warren Court was very fond of making tests. And, law students love tests. The more factors, the better, right? I'm not a fan of tests because it's usually not very helpful. So let's just look at each of these four factors, right? Is this regulation within the power of the government? Well, if you took common law from me or anyone else, you'll know that basically the government can do whatever they want, right? The federal government has nearly unlimited powers. There are very few constraints, especially in the 60s before we get to the 90s, right? So this one, check, right? That's automatic. Factor number two, does the regulation further an important or substantial government interest? Look, almost everything is an important governmental interest. It's very rare for a court to say, you know what, this law is just kind of stupid. It doesn't really, it doesn't really pursue a valid interest. We'll see a tweak later, but this one's almost always satisfied, right? Number three is where all the money is, right? This is really where the test turns. Is a government interest related to the suppression of free speech? Or is the government interest unrelated to the suppression of free speech? In other words, why is the government pursuing this interest? Is it to shut down a certain viewpoint? Or maybe there's some other justification, right? This is where this case really turns. What is the government's interest here? It's to maintain records, the court says. It's to maintain records. And is the requirement to keep your draft card safe designed to restrict speech? No, it was designed to help maintain records, right? If the government's goal is to maintain records, and they enact a law saying you have to keep your records clean, then that regulation is not about suppressing speech. It's unrelated. So the third factor is really where this entire case turns, right? It's really all goes to number 3. Okay. Do we believe that the government's goal here is actually protecting records, or is the government's goal to suppress anti-draft sentiments? Well, the court was probably right here, although maybe there's arguments on the other side. The fourth factor didn't really come too much into play, but the fourth factor is basically a strict scrutiny test, right? It's about narrow tailoring, right? If you get to number 3 and you say, you know what? This government interest is related to suppressing speech, then you ask, is this restriction narrowly tailored, right? Is it no greater than is essential, right? Are you using the least amount of restriction to get to your goal, or you're restricting speech in too broad of a fashion? All right. Again, 1 and 2 are almost automatic. Maybe 2 will not be satisfied sometimes, but 1 and 2 are almost automatic. Number 3 is really the linchpin. Is the government's interest trying to suppress speech, or is this just, unrelated? And if you do have a restriction on speech, is it too much? All right. Here the court says, this is about maintaining records. And the court agreed, yes, this does limit O'Brien's speech, but he can protest the draft other ways. There are a million ways for him to object to the draft: hold up a sign, sing a song, scream at the top of your lungs. So there are other ways that he can convey his message. So the restriction is not that bad. Just it's incidental. Now, if these 4 factors are sort of satisfied, that it's unrelated to the suppression of speech and the regulation is not that bad, then you review it in sort of deferential scrutiny, what we might call intermediate scrutiny, right? But if the interest is related to suppressing speech, then you really need a strict scrutiny framework, straight up. And from common law that generally laws reviewed with strict scrutiny are unconstitutional. So this is a case where really everything turns into the third factor. If you can get past factor number 3, you're going to survive your scrutiny, generally. Yes, Joe, go ahead.
Was there the only way to get a draft card was an actual draft card? Was there not a way to get a symbol of a draft card? Like I'm saying, if he
a fake
burned,
one, a fake one.
Yeah, if he burnt a fake, their case, they're saying, hey, you destroyed the records, and that's why we filed this case. What if it wasn't a real draft card? Does that matter?
Oh, he just made a copy of it? Yeah, you can do that. If it's an unofficial document, they're not going to punish you. Yeah, you could just make I don't know, Xerox existed, but you can just make a copy of it, right? But I think the symbolism was you're not burning just a copy, right? You're not playing. You're doing your actual draft card because you're protesting the law. It's an act of civil disobedience. So I think the symbolism would have been far less if you used like a fake one. Make sense?
It just doesn't seem to me like their case is really about burning the record. It seems like it is more of a censorship bill because we don't want you speaking out against.
Well,
right?
Yeah, I mean, we don't include the dissents in your book. And if you're, the book's long enough as is, it's thick. But if you want to read Justice Douglas's dissent in the case, Justice Douglas suggests that this was designed to suppress speech. So there were other perspectives here. Yeah, Nancy, go ahead.
Why don't they look at how the law itself was applied in this situation to his particular act, like that he was using this as an expression? And is that the difference between the intermediate and strict scrutiny? If they had gone to strict scrutiny, then they would have looked at the application of
Well, I think you have to look at the third factor really as a trigger for strict scrutiny, right? When Congress enacted this law, was it intended to punish speech or to maintain records? That has nothing to do with O'Brien, right? The inquiry in factor 3 is sort of objectives, like what was the intent behind this law? You would only look at this particular circumstance if you get to the strict scrutiny analysis, which factor 3 doesn't let you do it. That's a very good question, though. Yeah, this test should be the same regardless of what O'Brien did. It's looking at what was this law intended. You could ask, what if Congress has one intent, but the federal prosecutor has another intent, right? Maybe Congress in 1940, 48, was trying to maintain records because it wasn't, there were no hippies back then, but the prosecutors today are using an old law for new tricks, right? Using it for different purposes. And does that modify the analysis? The court doesn't really consider the intent of the prosecutors in bringing this charge. But I think prosecutorial discretion is an important component in even deciding to charge him. Look, you don't need to charge O'Brien with burning a draft card. You can just say, hey, stop it, give him a warning, let him go, right? You don't need to charge Johnson with burning the American flag, but they did. And then you have to go to court for it. Gavin, go ahead.
So to clarify, they are deeming like his conduct a form of speech, which is
yes
ultimately protected, but it's just it's outweighed by the compelling government interest here.
Yeah, I think the court accepts the fact that this is expressive conduct, right? There are a lot of cases, nude dancing, what you might call a strip club, is a form of expressive speech, right? There are cases where you have limitations on adult, on basically strip clubs. And I swear this is true. Strip clubs have put on performances of Shakespeare where you have the strippers reading Shakespeare, right? To get around these bands, right? They're naked, but they're reading Shakespeare to make a point. So the court treats almost everything as, almost all forms of conduct as expressive, but you still have to get past this O'Brien test, which is a little bit harder to get over than if it's just words.
Understood. Also kind of unrelated, but in your video, the fact that on the draft card, the name was Donald J. Trump, is that coincidental or is that intentional?
I made the video, so you're speaking to the author. I needed a high resolution copy of a draft card, and it was the best one I could find. That's why I'm glad someone noticed that. Yeah. There were no good high resolution versions I could find, and that's one I found very easily. There you go. I spent a lot of time finding the pictures for those videos. Hope you guys enjoy them. It was not easy. There was a lot of effort to go through archival footage of finding where people were burning draft cards. It took us 2 years, but worth it. Okay, who's next? Anyone else? All right, I think we're done with this case. So the O'Brien test is a sort of 4-factor test that's used when you're dealing with conduct that has expressive content. Okay. Then we get to our next case from Texas. We have a lot of Texas cases in common law. It just seems that we attract common law cases. I don't know why, but there are a lot of Texas cases. Brianna, you here?
Yes, sir. Hi.
Hello. Brianna, you want to give me the facts, please, in Texas against Johnson?
Yes, sir. So in Texas v. Johnson, Johnson was charged, and basically it was just a protest, but he burned a flag, and Texas charged him with that because they said he couldn't do it, but it went up because the Supreme Court says that he can do it. It's expressive communication, and so that's where the case focuses. Okay. All right. Very good. So if you do watch a video, this one I actually found the archival footage, which was kind of it was kind of old and grainy from like an old TV station, but I was able to track it down. You have a guy, Greg Johnson. His thing was burning flags. He liked to burn American flags, and he would go to protests all around the places, and he would burn flags. In fact, if memory serves, in the last year, he got arrested again for burning an American flag. I can't remember where he was, but he was somewhere. I think it was actually a Trump protest or something. But he went and he burned a flag. So dude's still active. He's still doing his thing. He was prosecuted under a Texas law that prohibits desecration of the flag as a venerated object. Venerated means like respected, like a respected symbol. And he was sentenced to a year in prison and a fine. Okay. So this is I think, a fairly good case to learn about how you apply the O'Brien test. Jessica. Yes, I remember. It's not Sarah, it's Jessica. Jessica, you here?
Yes, I am.
See, I remember. I remember names. I do. I try. I try hard at least. I don't always, but I try. Last year she yelled at me. I kept calling her Sarah because that's what it says on the sheet. All right. How does the court apply the O'Brien test in the Texas case?
Well, first, the court looks into the fact that the state, well, okay, getting to the third factor, right? We know
Right.
that the first and second factors are usually met.
Well,
right?
well, is the second factor met here, though? That's actually, I sort of caveated my answer before, right? Remember, the second factor is whether the I can't go my notes.
There's an important governmental interest.
Yeah. So does Texas have an important governmental interest in stopping the desecration of venerated objects?
Okay, well, it gives two reasons for its governmental interest in preventing the desecration of the flag, right?
Right.
And so the first one is that they're preserving the peace, preventing breaches of the peace. And the second one is preserving the flag as a symbol of nationhood.
Okay,
right?
yeah. Well, let's do the second one first. Does Justice Brennan think preserving the flag as a symbol of nationhood is actually an important governmental interest?
So I think he believes that he believes in preserving nationhood, but I think he thinks that preventing burning the flag
Good.
to preserve nationhood is where things go a little haywire.
Right. So does he think this actually, this law actually accomplishes an important interest?
No.
No. So this one actually flunks the second factor, right?
So I was thinking that it was I guess I must have gotten. I was just thinking that the government interest then would be whether it was anyway. It doesn't matter.
No. I want to make this point. I think you said two things. There were two things, right? Preventing breach of the peace. There's no evidence that burning the flag was breaching the peace. So that was an issue here, right? But Texas did assert an interest in court that said we want to preserve the flag as a symbol of unity. The audio and the video is actually from the prosecutor who argued who litigated the case. They let the trial prosecutor go to the Supreme Court. Probably not the best move, but she argued the case and she lost. She lost. But Brennan says the second factor is flunked because that's not a valid interest of preserving unity, right? People are allowed to dissent. There's no obligation for people to be patriotic and to love the country. That the state doesn't have the interest of preserving symbols that maintain unity.
So I guess I didn't catch exactly that when I was focusing, I think, a lot on anyway, I guess I just missed it altogether, but I guess I was more interested in the idea that like the burning was the speech part and the speech. Anyway, whatever. And I thought, but
well, do you want to do the third factor? I don't want to interrupt you. Do you want to do the third factor?
No. I think it's fine. I was just thinking when you said that about, I guess you know what, honest to God, I think I just took it as a valid interest that you would want to preserve unity anyway. I think that's just something I presume.
It's a presumption. No, it is. It's a presumption that everyone has the same idea of what unity even is. If you're a radical anarchist, whatever Johnson was, you don't share that vision. All right, let me move on. But thanks, Jessica. Thank you. Very good. So the second factor, I think, was flunked. And the reason why the second factor is flunked is because of the third factor, right? They're intertwined. The government's interest was maintaining a certain vision of patriotism. That interest is related to suppression of speech. Let me say that again. The government here was trying to suppress speech and promote patriotism, right? That was their interest. So really 2 and 3 are linked, right? If you flunk 3, you might also flunk 2 because the state doesn't really have an interest in suppressing speech. You see, it's kind of like a trap. It's Brennan is. Brennan drives me nuts, but he's very good at what he does. If you're pursuing suppression of speech, that is not a legitimate interest. So if you flunk 3 here, at least you flunk 2. You can probably split them in other cases, but here, if you flunk 3, I think you flunk 2. Right? And then once you flunk 3, you're basically in strict scrutiny land, right? You say, is this narrowly tailored? Absolutely not, right? You're suppressing a lot of speech. The court does mention Brandenburg and the court does mention Chaplinsky. And the court said, look, if you can punish a burning of a flag because it might lead to violence later, then what's left of Chaplinsky, right? This is why the imminent standard really, I read narrowly. The guy was burning a flag in front of a mob of whatever you want to call them, in front of a mob of people, right? Did that incite imminent violence? No. Did it make people probably want to go and do things? Probably, yeah. In fact, after this march, they broke into the department store and they robbed stuff, and they smashed glass, and they did what they do. So the court, what Brennan says is, if this is inciting imminent lawless action, then basically Brandenburg doesn't have any meaning, right? He's saying Brandenburg means what it says. You have to be very cautious before you charge him with inciting violence. And then we get to Chaplinsky, right? The fighting words, right? I am certain that people watching the burning the flag were drawn to violence. Imagine you were a veteran, or you'd served in a war, and you lost friends and family for defending the flag, and then you see this guy burning the flag. You might want to punch him in the face. I'm seeing people nodding on the grid. Yeah, you might want to punch the guy in the face. But Brennan says no reasonable onlooker would have regarded his expression of dissatisfaction with the government as an insult, an invitation to exchange fisticuffs. But that's precisely what happened in Chaplinsky. He called the cop a fascist. That was enough. So this is why I tell you, Chaplinsky is a sort of stepchild. Doesn't really fit anywhere in the family of First Amendment law. It doesn't really fit in anywhere. No offense to any stepchildren who are in the choir. I probably shouldn't use that phrase anymore. But you live and learn. All right. Next, I want to do a couple points. I want to move on to the third case. Brennan explains that this is what's called a content-based restriction. What does that mean? They're punishing him based on the content of his speech. His speech was against the United States, and Texas did not want that message to be conveyed, and that's why they punished it, right? They're punishing him for the content of his speech. If he was waving his flag and saying "God bless America" at the top of his lungs, he would get a medal, right? He wouldn't be arrested. He's being punished precisely because the content of his message is contrary to the government's position. All right. Questions on Johnson? Questions on Johnson? Yes, Nancy, go ahead.
It's always me.
That's okay. You asked very good questions.
Thank you. You said that the majority opinion says that this was a content-based regulation, but then in the supplement, it distinguishes between viewpoint and content discrimination, and I thought it was saying that this was a viewpoint discrimination.
Yeah,
so
I think it's both, actually. Yeah, so I was going to do that in a minute, but I'll do it now. Very often you'll have a law that bans speech based on its content, right? Where you can't criticize the government, right? You can't speak critically of the government. But imagine the government passes a law that says you can criticize Democrats, but you can't criticize Republicans, right? So you can be critical, but of only one party. The second law is a viewpoint discrimination, right? Because what you're saying is you can be critical of the government, but only part of the government that we don't like. Generally, content restrictions and viewpoint restrictions are unconstitutional. You can't impose them. The Texas law is unique because it's banning a specific type of message, right? The desecration of a flag. But it's also somewhat viewpoint discrimination, because if you're sitting there, giving a flag a hug, right, too soon, that will be permissible. You can do that. You can hug the flag all you want. And indeed, you can burn the flag as a way of disposing it. That was actually an important point, right? Actually, the proper way of disposing of flag is actually to burn it and bury the ashes. So the exact same act, if done with a different intent, becomes a crime. So viewpoint discrimination and content-based restrictions often blend together. We'll do more on those topics in later cases. I didn't want to do it too much here, but good question. All right, I have 12 minutes left for the. Oh my God, this class is so short. All right, who's next? Christina, you here?
Hi, yes.
All right, Christina, you want to help us out, please, with our third case, R.A.V.?
Sure. So
There was a minor, and him and some other juveniles burned a cross in the backyard of an African American family's home, which contravened a law in St. Paul. And that law basically said that if anyone has reasonable belief that their action is going to arouse anger on the basis of X, Y, and Z, and they listed race.
Yeah, what are just X, Y, and Z are important. It says arouse anger based on what are X, Y, and Z there?
Based on race, color, creed,
Okay.
religion, or gender.
Okay.
That they would be guilty of a misdemeanor.
Okay, good. All right. Thanks, Christine. I appreciate that. Very good. So the facts here are not like the facts in Brandenburg, right? These were not Klansmen who had a huge Klan rally. These were teenagers who basically broke into their into a neighbor's yard. They committed a trespass, so they absolutely committed a crime. And they basically taped together chair legs and they lit them on fire in the shape of a cross. This was obviously done to send a signal of hate, of racism, whatever label you want to use it. This was not designed, as a friendly gesture, right? This was a bad act here. St. Paul, Minnesota had a law that made it a crime to use a symbol, such as a burning cross, which can arouse anger, alarm, or resentment in others on the basis of race, color, etc. All right. What do we do with this law? All right. Who's next? Sienna, you here?
Yes.
Sienna, let's think about the O'Brien test for a minute. Was the purpose of this law related to suppression of speech?
I didn't interpret it that way. I thought it was to protect like marginalized groups, but I don't think that's how the Supreme Court interpreted it.
Oh, I think you're right about that. It was unanimous. It was 9-0. But let me just, I want to drill down this point just for a second, if I can, Sienna. How do you figure out the purpose of a law? Because the government will always come and say, we were trying to serve some higher purpose, right? We were trying to protect people who are, who've been oppressed racially oppression, right? Or we want to protect people from having to deal with these sorts of symbols. But the way to achieve that protection is to stop certain types of conduct. And that conduct could be expressive. So how should a court disentangle the intent question, right? Is the legislature trying to prevent racist symbols, or is the legislature trying to stop conduct that leads to these racist symbols, right? How do you disentangle those questions?
I don't know. I mean, I guess in this one, it was like arousing anger or something, not so much fear.
Just on one more point, arousing anger, it doesn't sound like fighting words.
It is.
Wouldn't this been a really good case to say that a cross burning on a black person's lawn is kind of like a fighting word?
It would have been.
But the court didn't do that, did it?
No.
No. Thanks, Sienna. Yeah, that's what I'm telling you guys. The fighting words doctrine, if there's any case that you want to see what's going to make a person want to punch in the face, lighting a cross on a black person's lawn, that probably would do it. But the court said, no. And the reason why I want to make this point plainly is because it wasn't just about fighting words. It was about fighting words on the basis of specific viewpoints, right? That if you went to someone's lawn and let's say you burned a wheelchair. Let's say you're a disabled person, right? And you burned a wheelchair. I don't know. I'm making up a stupid example. To say you hate disabled people, right? That wouldn't trigger liability under the statute because it doesn't enumerate disability. It only enumerates specific grounds. So here is where viewpoint discrimination comes into play. You're allowed to arouse anger on the basis of disability, but you can arouse anger on the basis of race and color and religion, etc. So the problem with the fighting words doctrine is that it's so narrow. You know, what if they just put a statute saying you can't arouse anger, period, in any basis at all? Well, that gets rid of the viewpoint problem, but you still have the content-based problem. So this statute was doomed no matter what happened. But I want you to see the difference between the viewpoint and the content-based, right? It only punished certain types of arousing anger statements on those 4 or 5 bases, the X, Y, and Z I think it was Sarah gave a minute ago. No, Sienna gave a minute ago. Or Christina, sorry. I'll get your names, I promise. So there's viewpoint discrimination. There's also content-based discrimination. I think in my last class, I made a point that a lot of people flagged in the chat where I said hate speech is not a thing in American law. I was like, what? It's true. In the American legal tradition, saying racist things is protected by the First Amendment. Look no farther than Clarence Brandenburg and the Klan rally he gave. It's speech. It's expressing an opinion that not very popular today, not well accepted in society. It was accepted more so perhaps in the past. But these messages are considered speech. And so merely saying racist things, whatever you want to say, by itself is not going to be punishable. They say, Josh, what about hate crimes? Hate crimes are a little bit different. That's where you actually engage in a crime and you have a certain intent, or maybe you call it a mens rea. Right, that if you engage in a crime, trespass, battery, murder, whatever it is, with a certain racist intent, there are certain criminal enhancements. But merely engaging the speech itself cannot be punished. In other countries of the world, that's not the rule. In many countries, engaging in racist speech is itself a crime. You could be thrown in jail for using a racial slur. That's not the case here. So this case, the fact that they're saying Chaplinsky cannot be used to punish this incendiary symbol, right, is significant, right? This case was 9-0, and I only have a few minutes left, so I'm going to have to summarize just a bit. The majority found that this was a content-based restriction. It's punishing speech because it's arousing anger, and you cannot do that. And the fighting words doctrine doesn't permit punishment here, because it's only certain types of fighting words, right? And they can't pick and choose. Look, Scalia wrote this opinion. Let's just be honest here. He would have overruled Chaplinsky in a heartbeat. He didn't have the votes, right? He wanted to get rid of it. So he basically narrowed Chaplinsky to basically null set, right? So it has really no significance anymore. But Nino just lacked the votes to overrule Chaplinsky. He couldn't do it. He needed Kennedy. He always needed Kennedy. Okay. Therefore, the St. Paul Ordinance was unconstitutional. I want to talk a bit about the concurrence, which is almost like a dissent because it doesn't agree with the majority. This was Justice White, Blackmun, no relation, O'Connor, and Stevens. And their opinion, right, didn't really agree with the majority on much. But what they did say was a worry about what's called overbreath. Overbreath. What is overbreath? This is a strange doctrine in law, right? What overbreath says is even if this particular incident with the cross burning on the lawn could be punished, this statute could be used to censor other speech that can't be punished. And because this statute sweeps in a lot of speech that should be protected, the statute's unconstitutional, right? In other words, even though R.A.V, those were his initials, R.A.V's conduct could be punished, the statute could be applied in other contexts that are unconstitutional. And because the statute may be unconstitutional in other cases, it can't be enforced here, right? It's an overbroad statute. There's overbreath, and you can't enforce an overbroad statute. This is a very strange area of the law. Usually a person only has standing to assert his own injuries. But under this doctrine, you can assert other injuries that other people may suffer. I am not a fan of this doctrine. In fact, Justice Thomas has signaled that this doctrine may be a little bit too broad. So I would not be surprised if this doctrine gets scaled back in the coming years. Yeah, Macy, go ahead.
How is that doctrine not in some form or fashion an advisory?
I knew you were going to ask that. Oh, I'm so glad you asked that. I was waiting for that question. It is. Justice Thomas, who maybe you may not like very much, but he often speaks his mind on these issues, says the courts don't have jurisdiction to consider challenges not before it, right? The court only have jurisdiction to consider the specific facts in the case before it, right? What's the injury? He's being charged for crime X, Y, and Z, right? I just got my evaluations from common law. A lot of people say that Blackman gives his opinion too much in common law. Yeah, too bad. Yeah, it's going to happen, right? Not so much in property, but in common law, I do. I don't know how this doctrine evolved the way it did. I think it's far too broad, no pun intended, right? I think it allows courts to halt statutes that are not properly before it. So I don't get the overbreadth doctrine, but I think it's almost like a cop-out. It's like, look, we don't want to endorse cross-burning, so we'll just have this other rationale because we think the statute goes too far. We just don't want to endorse cross-burning. There was another case. I see I'm out of time. There was another case called Virginia versus Black, involved cross-burning also. In the Virginia versus Black case, the conviction was upheld because the cross was burned to intimidate people, right? When there was an intent to commit a threat, right? You can't threaten people. I can't say, I'm going to break your head open, right? I can't do that. When the cross was burned as an element of intimidation, that was okay. So there are statutes that permit the punishment for cross burning, but the one in Minnesota went too far. It wasn't valid. So there are subsequent cases that permit bans on cross burning, but not this one. All right, thanks, Macy. Questions? Yeah, Joe, go ahead.
I mentioned some videos earlier with the voter ID cards. Where are those located?
Oh, so do you have the supplement?
I do.
Right. So in the supplement, there's a card on the front cover with a little scratch off. Yeah. And if you go to casebookconnect.com, you will have access to an entire video library.
Okay. All right.
Yep. I've opened the minute poll. If you can just please put in your reflections or questions from the class. I do read those. And also the instructions for accessing the videos are on the syllabus as well. So that's been there since day one. Okay. All right, everyone. I will see you all on Monday. Have a wonderful weekend, and thank you so much. Oh, office hours about 20 minutes, about 1:45. Thank you.